Hello everyone, it's Rick. It's been a while. It's August the 12th, 2026. And let's get started. If you need to contact me in exchange for paperwork or to challenge child support, please send emails to the addresses below. Always check your spam folder for my response. Please use all of my email addresses to ensure I receive your message. All right, I've been busy. I had a couple of people I've been helping. I've had a few people actually. Two recent victories. I got one guy very close. Two guys. Jersey and Florida. Florida guy, they just pushed back the date because they received the paper. They received the paperwork and then they pushed back the hearing to the end of the month. So my paperwork is very effective. I have a methodical way of challenging jurisdiction. So let's see what methodical means. What is the definition of methodical? Done according to a systematic or established form of procedure. That's what I do. So what I do is I challenge jurisdiction. I challenge the sufficiency of the pleadings. I challenge the proper parties. I challenge if there's any evidence. And it's working. Okay, so let me just give you an example. So this was a notice of appeal for a guy in New York, Brent. All right, he had the case started in January. They immediately issued a temporary order, and I wasn't with him then. Okay, so anyway, he had a hearing on June 1st because we filed my objection, my non-statutory objection, and in it, we demand a bunch of things. So they immediately they issued a fact-finding hearing, which you can see right here. We filed paperwork for that hearing, and what happened was the fact-finding hearing. They demanded that the mother provide proof that he's not supporting his children. And anyway, this is what happened. The order of dismissal dated they issued a dismissal on that date, vacating the temporary order of support from January 12th, 2026 on the above named case has been processed. Such and such client may have received overpayments while the temporary order was in effect. Please be advised that parties will need to resolve any matters regarding overpayments amongst themselves, meaning they're going to have to sue each other. So they're not going to send back any overpayments. But this is proof that there's a dismissal. Okay, so we're going to talk about what the paperwork we filed, what it asked for. Okay, so I have this, I have Adobe, and they have all these tools. And one of the tools they have is to generate a podcast. So there's a couple of AI podcasters, and what they do is they summarize the actual paperwork we filed. So get ready to listen to them.
Jurisdiction in family court is completely backwards. Jurisdiction cannot be based on assumptions, stacked inferences, or mere conclusions. It must be proven affirmatively on the record, fact by fact.
Really? That's wild. I always thought courts could just infer jurisdiction if the circumstances seemed right.
Yeah, that's the common misconception. But actually, jurisdiction is the gatekeeper of any case. If those jurisdictional predicates don't clearly appear in the record, the court has to dismiss, no matter how strong the underlying claim might be.
Wow. So this isn't just a technicality. It can literally decide whether a case moves forward or not. That has huge implications for litigants, rights, and even the court's authority.
Exactly. And by the end of this episode, listeners will understand why jurisdictional challenges demand rigorous, record-based proof, how to frame and preserve these challenges effectively, and why due process concerns about neutrality tie directly into jurisdictional rulings.
So let's start with the fundamentals. Jurisdiction is the very first question a court must answer, right? Before even looking at the merits or relief.
Right. Courts have to assess jurisdiction first. And interestingly, they can raise jurisdiction issues sua sponte. That means on their own, even if neither party challenges it.
That's a powerful safeguard. But jurisdiction itself breaks down into two separate inquiries?
Yes, two distinct ones. Subject matter jurisdiction asks whether the statute actually grants the court power to hear this type of case. Then, personal jurisdiction asks whether the court can bind the parties involved.
And in family court, jurisdiction is strictly limited by statute, correct? So the court can't just assume jurisdiction based on vague or implied facts.
Exactly. The limited jurisdiction record rule means...
This is family court in New York, okay?
Essential jurisdictional facts must affirmatively appear in the record. No assumptions, no inference stacking.
Inference stacking. That's when one assumption leads to another without direct proof, right?
Yes, and that's a big no-no here. Each jurisdictional fact has to be supported independently by admissible evidence. Think of it like building blocks. Each block must be solidly in place, not propped up by shaky assumptions.
That analogy really helps. So when framing a jurisdiction challenge, what does the motion typically look like?
Usually it pairs a dismissal request with a demand for a fact-finding hearing. The motion asks the court to identify jurisdictional predicates in a written response, forcing the court to tie jurisdiction to specific record facts.
And what kind of threshold defects are usually asserted?
Common ones include lack of standing or capacity to invoke the court's authority, no viable claim supported by proof in the record, and preserving personal jurisdiction objections through special appearances.
Special appearances. That's a tricky area. You have to appear only to contest jurisdiction, not to litigate merits, or else you risk waiving objections, right?
Exactly. It's a strategic move. Once personal jurisdiction is challenged, the court must decide it first before any other issues. And you have to analyze the full jurisdiction stack: service of process, statutory authority, and constitutional due process.
That makes sense. And what about subject matter jurisdiction? How do you test that?
You start by identifying the specific statutory trigger under Family Court Act Article 4 provisions. Then you map each jurisdictional prerequisite to a provable fact in the record. Courts must reject conclusions or inference stacking in place of admissible proof.
So jurisdiction has to link directly to the pleaded claim. If the claim lacks factual support for jurisdictional predicates, you argue no subject matter jurisdiction.
It's a principle of law. If there's no facts, there could be no application of law. So if there's no evidence, there's no facts. All facts have to be proven by evidence. Okay, so that's the best way to challenge subject matter jurisdiction. Usually, you would challenge both together, personal and subject matter jurisdiction. Because normally the courts have subject matter jurisdiction in a controversy, a family dispute. But the best way to do it is the way I do it, is on paper.
Exactly, and that ties into party status and cause of action. Standing and capacity are threshold issues. The petitioner must have record proof of a legal interest and right to invoke relief. The respondent must be a legally recognizable entity subject to the court's authority.
And if those party defect arguments hold, you frame them as grounds for involuntary dismissal?
Yes, and it's important to separate claim sufficiency from jurisdiction. ACPLR 3211 motion tests legal adequacy, not factual merits. You pin down the claim's essential elements: legal right, duty, breach, and demand evidence linking each element.
So if the claim can't be sustained on the record, dismissal is the proper remedy.
Right. Now there's also a due process overlay here. Due process requires a neutral decision maker, not just a correct outcome.
I saw that the motion might argue that IVD incentive structures create an appearance of financial interest, which could undermine confidence in fact-finding.
Yes, that's a subtle but critical point. Allegations of bias or institutional interest must be grounded in the record and connected to recusal standards. You want a written ruling explaining why impartiality is preserved.
That's a powerful tool to ensure fairness. What about the relief requested in these motions?
Typically, you ask the court to identify specific record facts establishing jurisdiction and seek written findings supporting any exercise of tribunal authority. If the record is insufficient, you request dismissal as a threshold remedy, not a merits ruling.
And fact-finding hearings come into play to resolve disputed jurisdiction, standing, and capacity facts before enforcement steps.
Exactly. It's about making sure the court's authority is properly grounded before moving forward.
So what are the key practice takeaways here?
First, preserve jurisdiction defenses by raising personal jurisdiction objections at the first meaningful opportunity. Limit participation until jurisdiction is resolved to avoid implied waiver.
And insist jurisdictional predicates affirmatively appear in the record. Attack conclusory assertions and require admissible proof, not stacked inferences.
Also, request written findings identifying the evidence supporting jurisdiction. Sequence threshold defects logically. Subject matter jurisdiction first, then personal jurisdiction, then standing.
And test party capacity on both sides before litigating substantive elements. Tie every argument to statutory facts and procedural posture.
Exactly. It's a rigorous, methodical approach that protects litigants' rights and the court's legitimacy.
So to wrap up, jurisdiction in family court isn't just a formality. It's a strict evidentiary gatekeeper that demands clear, affirmative proof on the record. Without that, no case can proceed.
Right. And understanding how to frame, preserve, and press these challenges is essential for effective litigation strategy.
Plus, keeping an eye on due process and neutrality concerns adds an important layer to the analysis.
Absolutely. It's a complex but critical area that shapes the entire litigation landscape.
Well, that was a deep dive. Hopefully listeners come away with a sharper grasp of these jurisdictional nuances.
I'm sure they will. Thanks for unpacking this with me.
Anytime.
It turns out what many...
See, they do a better job than I can. Anyway, yeah, so it's a methodical way to challenge jurisdiction, proper parties, impartial due process. All hearings are supposed to be fact-finding hearings. And an inference is a suggestion, which is why you have to be careful answering questions. An inference that may strongly suggest you're not supporting your kids is, oh, I haven't seen them. I haven't seen them. I haven't seen them in years. She won't let me see them. Things like that. Okay, so that's why it's very important that you refrain from answering questions. Again, the best thing to do is just file paperwork to start things off. And, my next video I'm going to do very shortly. I just had a guy who had over $30,000 in arrears in California. And the case started in 2018. And the case was just zeroed out. Okay? Just using my paperwork. Okay? So, anyway, I'm going to end the video. Again, if you're interested, this is how you can contact me. All right. And I'll talk to you guys soon. Bye.